All right, we are live. All right, we hadn't been here in about 4 weeks. Welcome to our monthly episode of Work Comp Today. Dave, how's your day going so far?
Great, thank you. How's yours?
It is fantastic. You know, it's one of the things that I so look forward to each week is your unbridled enthusiasm for being a work comp nerd for an hour. And speaking of our fellow nerd, we need to welcome our buddy, Steve Goozee. Goose, how's your day going, bud?
Oh, it's been fantastic so far. So
See, Dave,
see how it goes.
Enthusiasm.
Yeah.
Well, guys, we are, as we do each month, this is our Work Comp Today YouTube live show where we talk about any topics that are newsworthy in the previous month that deal with employers, employees, and independent contractors. And typically it's going to be injuries in the job place or some version of that and all of the laws that impact our practices. And a lot of these articles that we find are around the country. Sometimes we try to bring in an Alabama case or piece of news like we have today, but not always. We do always seem to find Amazon or Dollar General or some of those big box stores. But before we jump into this month's article, Steve, if you would, share with folks about your practice and stuff like that so we can get going on our talk today.
Well, as you guys know, I am a solo practitioner and have been since around 2007. I have been practicing now for 35 years, primarily representing plaintiffs in personal injury and workers' comp cases. And in the last 15 years, my practice has expanded to mediating cases that started out primarily in workers' comp, but now has expanded to all areas of tort law. I still do lots of workers' comp in the cases that are related to it, retaliatory discharge, co-employee cases. But I'm also doing product liability and car wreck cases too. So that part of my practice is really kind of taken off, and it consists about almost 70% of what I do. I try to keep about 35 to 40 active litigation files because I don't want to stop being a litigator, but I really do enjoy the mediation side of it. And it's been a great experience and very worthwhile part of my practice.
And Dave, we have had the pleasure of knowing Steve for a couple of decades now, getting to do casework with him. And he's always been one that we've looked up to. Not that because he's that much older than us, but he just has that much more knowledge than us when it comes to our casework. But
Steve and I worked together on some cases years ago, and now Steve's one of our primary go-to mediators for our work comp cases. So we see and talk to Steve regularly, and does a great job with his mediation practice.
Thank you.
That's exactly right. And we'd say that even if he wasn't sitting here. All right, fellas, let's jump into our first article. This comes out of New York. Judge rules NYC. Oh, this is a hot one. Oh, it's a good one to start on. Judge rules NYC vaccine mandate arbitrary. And what's that other SAT word? Capricious.
Capricious.
Steve, we'll let you run with this one to start with. There's so much to unpack here because this is news. It's changed 3 times probably since this article came out. But what about this article that may impact our practices, if any? Let's just assume that it's Alabama as well, which we know it's not.
Well, I haven't run into too many issues in the comp world that involve the vaccine, but in this particular case, the New York judge ruled that a vaccine mandate by a municipality for its employees was basically arbitrary and capricious because it didn't apply it equally to all the people that they either hired or contracted with. And I think in this case, they reversed the requirement that employees for this municipality have vaccines while still allowing these independent contractors to not be vaccinated or have other excuses of why they are not vaccinated. I think they were like athletes, artists, performers that worked for the city by contract, but the judge ruled because they didn't apply the mandate equally to everybody that was under their employment, that it was arbitrary and capricious and therefore unconstitutional. Application to Alabama law, I'll leave that up to you guys. I don't even know where we are on that in Alabama.
Dave, I guess where I have seen it the most often in my world is because of the impact of various professional sports, mainly with the NBA in New York City. But I'm going to assume, and here's where I get in trouble, this is not going to impact the state of Alabama with a similar ruling anytime soon. Do you see anything differently?
I'm not aware of any pending case like this in Alabama, but certainly if there is one, then the Alabama court can look to this New York Supreme Court decision as give it some guidance on this topic.
I think maybe one of the things that's going to play out afterward, and maybe you may have seen this in other articles or in the news, is what about folks who refused to get any vaccines and then they were terminated from their jobs? Are folks going to be getting back pay and job reestablishment or reinstatement? Is that going to be one of the collateral issues in the upcoming months?
Well, it certainly was. Oh, sorry,
Yeah.
Steve. Yeah.
I was about to say that's what the judge did here. He ordered reinstatement and back pay for those that were affected by the mandated requirement of a vaccination. And I've heard of employers exploring that here, whether they can require their employees to be vaccinated or not. And then the other side is, what relief do they have for the ones that either have a religious or a political inclination not to be vaccinated, not just purely for health reasons, but it's a very touchy subject for a lot of people, because we have a lot of anti-vaxxers for various reasons. And there are some people that can't be vaccinated because the chemicals that are in the vaccination itself, they can't tolerate them.
Right.
So what do you do with them? Do you require them to present a negative COVID test, on a weekly basis or on a daily basis? I know some employers that do require that, some law firms that have required that, without getting into specific ones. But that has affected Alabama employees.
Question for Steve. Steve, have you mediated any COVID-related work comp cases?
I have not. In fact, I've got a case right now that's COVID related, but it's not because the COVID exposure occurred at work. What happened was my guy, who unfortunately died, contracted a very serious interstitial lung disease from an exposure at work from chlorine dioxide. And when he went to go get treated for that at the hospital, he contracted the COVID, and the doctor, the main treating physician, has opined that the combination of the exposure at work with wasn't an explosion, but a machine let out a lot of this chemical, and he was rushed to the hospital, and the doctor opined because of his weakened condition in his lung, that combined with the COVID to produce his death. And that's not in litigation yet, but it's I've got a lawyer that's defending it already, and they want to look at resolving it before I do file suit. And the statute comes up here in December, so we're going to either have to get it resolved or I'm going to have to file that one. But
Well,
no, I have not. I haven't mediated a COVID case, and I have not filed a COVID case.
Going back to our New York article here about the vaccine mandate, we all know that our state is not exactly one of the more progressive states around. So I'll be curious to see if there's any impact in Alabama on that. But guys, let's put a cork in that one, and let's move on to the next one. This is nationwide. This is Dollar General facing $1.6 million in OSHA fines. Now, Dave and Steve, I know we've all had OSHA involvement in our cases from time to time. Sometimes they can be huge help because they do a lot of the investigation that help to kind of show where the errors or where the company misstep. But
yeah, in this particular case, they had some employers, Dollar General employers were involved in the fine. So it does kind of, it has affected our state.
yeah,
I think it was because they found that the Dollar General warehouses weren't providing adequate slip and fall protection, didn't have the lanes in the warehouse cleared properly, and also fire safety hazards, and having outdated fire extinguishers and things like that.
you know, I assume, let's see, David, it says 18,000 stores, 47 states. I'm going to assume that most of these buildings, when they're built, they're kind of cookie cutter. When they figured out the pattern or the construction plans that they want to do, I assume most all of them are very similar. So I would be curious, Steve, and Dave, 4 willful and 10 repeat violations for what you just were describing. It just sounds like that Dollar General's really got to pick up their game when it comes to following what should be pretty standard protocol for safety. Dave, wouldn't you think?
Yeah, I mean, these stores are similar size, similar layouts, and but they are consistent at blocking exits and stacking things at unsafe heights and causing or creating trip and fall hazards for their employees. I want to address the fines that were discussed in the article. So they were, this most recent investigation, Dollar General was fined $1.6 million by OSHA, and I'm sure they'll appeal that. And the article also says they've been fined almost $10 million in the last 5 years. So $10 million in the last 5 years. Because I go above and beyond, I did a little research on Dollar General. Any idea what their profits are this year?
Oh, it's got to be in the billions.
It's a little more than $10 million, projected at $10 billion this year.
Mm-hmm.
So, what's a couple $1 million, to these companies when you're earning, billions of dollars a year, when you're putting your profits above the safety of your employees. So.
Yeah, and it doesn't really help us out very much from a comp perspective because we don't have to prove negligence or willful violations unless we're talking about core safety or co-employee type of activity. But this sounds like a more of a corporate thing. But I've had quite a few Dollar General store cases over the years, and they involve slip and falls and inadequate provision of safety equipment for lifting and things like that. So it's not a surprise to me that they've gotten fined by OSHA.
All right, fellas, this brings us to the Amazon portion of the show, because it's, again, similar to Dollar General, one of the bigger employers in the country. Amazon usually makes an appearance. We've been doing this show for more than 3 years, and I suspect they've been in about 25 of these episodes. Amazon workers win partial revival of COVID-19 safety lawsuit. Either of you fellas take a particular interest in this one? Want to kick it off?
Well, I mean, if I had some COVID cases, I would for sure. But it's interesting that, because COVID can come from any number of sources. I mean, some person who works for a particular company, even if they don't have good COVID-19 protocol, you can still go to a grocery store or get on an airplane and get the COVID. So it's still going to be tough to prove that what happened at work is what actually brought that malady along. That's the problem I see with the COVID cases, and that's the major defense is how can you prove it happened here? But obviously they proved it here in this New York case because they got some type of recovery.
Yeah, Dave, I know that a lot of our cases or a lot of our articles also come out of New York or California or just more progressive, I'll call them more states that have more progressive laws, maybe a little bit more protections than we do in the South, particularly in Alabama. But I don't know if this were to sit in Alabama, if I don't even know if we'd get this far, because we have no presumptions. We have very little protections. And as Steve just said, to connect the dots between where you were exposed as opposed to any other place in the world outside of work makes your case so very difficult in Alabama.
Yeah. Well, as we talked about before, Alabama is an employment at will state. We don't have a lot of unions. What's interesting about this case and the facts of this case is that it involves workers. And I think we've talked about this very group. It involves workers at the Amazon warehouse in Staten Island that earlier this year became the company's first unionized facility. I'm pretty sure we've talked about that in the past few months. So they've got more protections, and here they are, having some success with getting some protection from the exposure.
Steve, you having fun yet?
Yeah. What's another interesting thing about this case is it extended the protection not only to the workers, but to the workers' families.
Yeah.
Which would be beyond the comp situation. But that's interesting that they said that they had an obligation not only to protect the workers, but their families, but presuming, I guess, that the workers would come home with the COVID and spread it amongst the family members. But that's an interesting part of that case.
Yeah.
It really is. And Steve, you're now getting the hang. You're 3 articles in, and you're seeing why David affectionately calls this work comp for nerds, because it takes a very specific audience to follow this show on a monthly basis. But for those of you just tuning in or will watch us on replay, we've got our friend and colleague, Steve Goozee, who's a fellow Birmingham lawyer, mediator, and just all around great fella, is our guest this afternoon. And Steve, once again, I want to thank you, because with you as our guest and with Eli as my cohort down there, you really are bringing up the quality of this show today that we don't rarely see very often.
Yeah, I saw where Peyton and Eli had President Obama on the other night. Now, I missed it, but I heard it was a pretty good performance. And so I hope I'm adding some credibility to this nerddom that you've created here.
Well, I would dare say you're north of the Marshawn Lynch appearance.
Well, thank you for that.
And improving. You're going up the ladder.
Somewhere between Marshawn and Obama, I'll take it.
All right, fellas, we're going to head out to Alaska for our next one. High Court upholds award. And sometimes I'm telling you, sometimes these titles are written because they know I'm going to bring them into this show. High Court upholds award to worker injured after using cocaine and alcohol.
Good clickbait. That's what that is.
Seriously.
Mm-hmm.
And I
It's
guess
a really interesting case.
when you work
And
Alaska,
it has absolute applicability to our same statute, where there is a defense that if you're drunk or if you're on drugs, that's a defense, but it's the employer's burden to prove that contributed to the accident. And this court found that it didn't, said that the ladder that was involved was defected anyway, and an unimpaired person could have had the same fall. So, what does that? To say it's okay to do cocaine and drink beer before you get on a ladder? I don't know. But
just make sure the ladder's busted. Yeah, make sure the ladder's busted.
Well, they're saying he didn't. One of the defenses was he should have inspected the ladder as if it had a latent defect to it. And but it is very much in lockstep with Alabama law that if you're going to have that defense of drunkenness on the job or intoxication of any form on the job, it is the employer's burden to prove that caused the accident. Otherwise, it's not a defense.
Well, he must have been, I guess he was flying in one regard when he fell 30 feet, but apparently the evidence doesn't show that his intake of cocaine or alcohol impaired him in that situation. But
it might have mitigated his injuries, though.
But you know what it is, guys? This is yet another similar fact pattern that we've all handled many, many times. falls and horrible accidents and injuries that they lead to. And 30 feet is no joke. I don't care if you're impaired or not. You're going to get messed up if you're falling that far down.
Yep.
Yeah, I was wondering, after reading the headline, and then just a few paragraphs down, they took doctor's testimony and it said that the plaintiff, based on his level of blood alcohol, would have had impairment of balance, speech, reaction time, and judgment. I'm thinking, well, how are you gonna beat that?
Mhm.
And it was just a few paragraphs later when, it was busted ladder. Yeah. Very interesting.
Interesting. But like I said, it's the same rule we have here that they had up there in Alaska. It's the employer's burden to show the connection to have a defense.
All right.
Not that we're promoting that. We're not promoting that.
We're certainly not promoting it,
Mhm.
but it happens. And I'm sure that our respective practices will have cases to look at, unfortunately, in the probably not too far distant future. Similar
Kids.
calls.
Yeah, kids, the lesson here is don't have drugs or alcohol in your system when you go to work.
Yeah. All right, fellas, let's move on to our fifth. And this will be our final article for this month's episode. And we're coming back to Sweet Home, Alabama. We've got OSHA, we've got a cabinet manufacturer, and we've got a fatal electrocution. Dave, you recognize any of the parties or the folks involved in this one?
I think I remember reading about it when it came out. When it happened. Read it online, but don't recognize the employer, Wellborn Cabinet Incorporated in Ashland, Alabama. I guess that's Clay County.
Yeah,
Yes.
and we've had some dealings with Wellborn in the past.
Okay. Well, this is awful. A 33-year-old employee of Wellborn died. He was electrocuted, and just horrible. This happened back in March of this year. And OSHA came in and inspected and found several problems. And this company was, OSHA has proposed a $115,000 fine and penalties against the employer.
Does, in your experience, Steve, what typically will get OSHA involved in a work-related accident, injuries, or fatality? What kind of triggers? What are those parameters OSHA's looking for in your experience?
Well, whenever there's serious injury or a fatality in this type of environment, like at Wellborn Cabinets or at, any manufacturer in Alabama, OSHA is going to come in. And so, yeah, it's the seriousness of the injury that's going to bring them in. That's what I always see. I don't think, definitely fatalities. They're going to investigate, and they're definitely going to look really hard to find some kind of fault. And there will be a citation in most cases, what I've seen.
What this article doesn't show us, but I'd be curious, is if there's any third-party cases here, meaning, were there any other subcontractors involved? Was it completely a Wellborn event on their property, their equipment? Maybe the fellow was not the fellow who was electrocuted. Was he properly trained by a third party? There's so many things that we all go through when analyzing potential new cases, but nonetheless, it doesn't take away the fact that man lost his life.
Yeah, and I'm not at liberty to talk about the specifics of this particular case that I'm aware of that happened in South Alabama. It was not the employer's fault that the fatality occurred. It was actually a subcontractor that was supposed to come in and clean up some substances that caused this person's death. So yeah, the subcontract, of course, then that brings on a third party suit, right?
Yeah.
Not just a workers' comp death case. Now you have a third party case if OSHA finds that a subcontractor was responsible for the negligence or the willfulness that produced the death or the serious injury.
And, David, that kind of leads us to off of this article, but to a bigger picture, that when any potential new client or family member calls our firm or Steve's firm with a case, we can't just look in a tunnel, so to speak, at there only being a workers' comp case against the employer. Without us getting too far afield, what other types of cases, and Steve's mentioned one or two just now, do we typically look for or ask questions about to see whether or not there's other avenues of legal theories to recover for?
Sure. A pretty common example that we see is someone who's working and their job involves a lot of driving, and they're involved in an automobile accident that's caused by what we call the third party or the tortfeasor or the other driver. And so number one, there's a car wreck, there's a negligence case to pursue, there's a work comp case to pursue, and then depending upon the injuries, you know, if they're disabled, you might be able to help them with Social Security disability. And, you know, again, depending upon the facts, there might be a products liability case that the car something wrong with the car. There's lots of examples just coming out of one accident that the potential cases that need to be reviewed. One other that I just thought of, because Steve's on here, is that if the employee is fired because they made a work comp claim, then there's a potential case for retaliatory discharge, which means the injured employee was fired solely for making a work comp claim.
Steve, can you think of any others off the top of your head, or did
Well,
they-
yeah, I'm seeing
some?
for a while there, back in, I think, in showing my age anyway, back in the 90s when the 93 Act amendment came out, opening liability up to co-employees. Yeah, if you can, it's good and bad. My point is, I'm seeing a lot more of those lately, co-employee cases. But when you have a co-employee case, which means you have to prove that the supervisory co-employee or the safety co-employee intentionally injured you or acted with intent, or with removal of a safety guard where intent is not needed to be proven. I'm seeing a lot more of those cases. They kind of died. I just didn't see a lot of them in the last 5 or 6 years, but I'm seeing more and more of those. The problem with those cases is the act is specific that the case is against the co-employee, and it's up to the employer as to whether or not they want to defend and indemnify the co-employee. And you never see that if it's just a co-worker.
Right.
But sometimes they do step in and indemnify and defend a supervisory employee or a safety manager or somebody like that. But a lot of time, even if you have a really, really good co-employee case, you'll never collect any money from it because there's no insurance involved.
Well, fellas, let's pivot off of our articles from this month. And what we typically do at this time, Steve, is we take 2 or 3 or 4 areas of work comp practice in Alabama. We compare them with our guest's home state. Well, we're going to stay home since you're from here, but I've got 3 topics I want to throw out that are ones that we see all the time, almost daily, if not weekly, and they're real sticking points for our clients. And when they become sticking points, they become stressful. And when they're stressful, then we've got a client that really needs to be treated with kid gloves, if you will. So I'm going to throw one out, and I want to talk a little bit about it before we wrap up for this month's show. Dave, I'm going to let you start with this one. When we have an injured worker who's going through their medical care and their authorized treating physician announces to them, you've reached maximum medical improvement, that triggers a lot of things, but one of the most pressing things is those weekly or bi-weekly comp checks that they've been getting because they're not working by law are going to stop almost exclusively because of the way the law operates. So I want you to address briefly, what does MMI, maximum medical improvement, mean? And then what's this stopping of checks and how do we deal with it?
Sure. So MMI is maximum medical improvement. that is the point in time where the authorized doctor says that the injured worker is about as good as they're going to get. They reach their baseline recovery. And it doesn't mean they're done treating. It just means they can continue to treat after MMI, but it's just that point in time where the doctor's done about all they can do to get them back to work. And once you reach once you reach MMI in Alabama, then by law, the TTD checks stop. TTD is temporary total disability, and that's 2/3 of the worker's average weekly wage. So we are an MMI state. So once you reach MMI, TTD stops. And at that point, a couple of different things will happen. The injured worker might be able to go back to work. They may not be able to go back to work because of work restrictions, or they can go find another job. Or if they can't, then we either file a lawsuit or start pursuing settlement negotiations.
But in the meantime,
Yeah, I was going to say,
here's your injured
what's
worker
going on with your client?
doesn't have any income, right?
Yeah,
A lot of times what you also see is when they reach maximum medical improvement and the employer takes a position, well, we don't really have a job that they can do under the doctor given restrictions. But they also want to avoid liability by doing or creating what we call a sheltered employment or a made up job. Hey, we want you to stand in the corner and answer the phone calls that never ring, or the phone that never rings, or, doing tasks to avoid comp liability, but without a meaningful job. And the question becomes, is that the job that they created for you, is that actually a job that you would hire somebody else to do, or is it something you're simply doing to avoid the appearance that you might be sheltering an employee that's actually permanently and totally disabled? But the other frustrating thing is, and we were talking about this before we started, is your worker gets returned to work because he's at MMI, or he or she's at MMI, and the employer doesn't have a job for them. And there's really not a very marketable employee at that point, so they can't go out and look for another job that pays them the same kind of money where they were working, like they were working at Hyundai. They don't want to go get a job at McDonald's or Walmart Greeter or something like that. It's a big problem for us, but I'm not aware of anything under the current statutes for workers' comp that protects a worker in that situation. And that's unfortunate.
Yeah, what we tell them is it really has the impact or the effect of two things. One, it makes you basically unemployed by your employer, the one where you were working when you got hurt. But two, it potentially makes your case more valuable. And then unfortunately, we have to go through that whole line that says you're never going to be made financially whole because Alabama law is just not set up that way. But anyway.
Well, the third thing it does also, which is a positive thing, it can force the case into a settlement situation where.
See, there's the good mediator in him, Dave, right there. Always thinking,
Always
trying to
looking at
get
the
some
right
resolution.
He was just biding his time, waiting.
Yep, I was just trying to promote my business. But yeah, I mean, when you get to an impasse like we talked about before that started too, is you get to a point where the authorized treating physician has said, I'm declaring the worker at MMI, but your worker tells you, I don't know what they're talking about. I need more treatment. They're obviously working for the employer. They're not looking out for me. And so you panel away from that doctor. And the problem that we're running into, a lot of us, I hear it a lot amongst the plaintiffs' lawyers, is that when we're requesting these panels, the panel doctors are turning them down left and right. And it might take them 2 or 3 weeks to review records, and then they turn them down. So you get another panel choice. That goes through another 2 or 3, 4 week period. That doctor turns them down. And there's nothing under the law that we can do to, stop that from happening. And it's becoming a big problem. At least for me, it has been.
Yeah, that leads us into the second topic along these lines, is about what are known as the panel of 4. That's an injured worker's right to have a new doctor potentially take over their care. But there's a lot of strings, if you will, because of the way the compact is set up. Dave, who controls the medical care in an Alabama work comp case? Who pays for it? Who really has their hands all over it that creates these problems for our clients a lot of times?
Alabama is known as an employer-directed state. And what that means is the employer, work comp, chooses the initial treating physician. They pay for all the medical bills. And when the injured worker wants to use a panel of 4 to get a new authorized treating physician, work comp is the one that puts the 4 doctors on the panel. So it's great insurance in the sense that it's 100% free to the injured worker. However, again, the employer or work comp is the one directing the medical care by choosing the doctors, paying for the medical treatment, and work comp has to authorize all that medical treatment that it's ordered. I mean, from prescriptions to therapy to diagnostic exams to referrals, that all has to run through the work comp carrier. And that can be very frustrating to the injured worker.
Well, another thing that's frustrating is this. There's a 2-pronged requirement for you to get a panel of 4. The first one is an easy one. Your employee doesn't like a doctor anymore. They're dissatisfied with his treatment. But the second thing has got to be that there's got to be a showing that there is a need for further treatment. And most often that the authorized treating physician that you're trying to get away from is saying, I've done everything I can do for them. So there is no need for further treatment. And one way I've tried to avoid that, and I know some judges in at least Jefferson County will support this, is if you provide an affidavit from your client, despite what the authorized treating physician says, you provide an affidavit from your client saying, I need more treatment. I don't care what the doctor says. I'm hurting, and that treatment could be pain management. It could be, something like if it was an orthopedic injury, maybe we need pain management now. But it's a huge hurdle. And then the only other time you get to use a panel of 4 other than that is if surgery is recommended.
Yeah.
That's the only time you can use the panel of 4 a second time. The employers control the medicals, and it's very hard for us plaintiffs lawyers in many instances.
Steve, sometimes in those situations where the ATP, the authorized treating physician, says there's nothing else to do for them, we might send our client to their primary care physician or have the PCP make a referral, let them go to an appointment and get it documented what's going on. Then we could maybe use that if we have to.
Yeah.
But the other thing I was going to say, and I bet you both will shake your head in agreement, nothing moves as fast as the client wants it to when it comes to medical care appointments and getting things done.
Well, once in a while you luck out and you get a really, really good case manager. Unfortunately, most of the time the case managers are hired by the insurance companies and they cater to them. But once in a while you run into a case manager that's on top of things and really cares about your client, the patient, and helps you out. But more often than not, it's like you said, it's very difficult to get those medical appointments made. And then, we talk about case managers too, and another topic about.
Oh, we have.
And I know you have.
Yeah.
But sometimes you get a good one and that helps.
Oh, it helps tremendously. And most of them are great. But before we conclude, Steve, I want to go back to part of your practice.
Okay.
Part of your practice that David and I have been able to utilize for several years now, and including this past week, most recently, is the mediation process. I want to stick in the process of the work comp world. And why is it that mediation works so well quite often, percentage-wise, in the work comp case? First of all, what is mediation? And second of all, why is it beneficial quite a bit to the injured worker?
Well, I guess the glaring statistic that I can use is that, and I think most mediators will tell you this, is that 75 to 80% of mediations result in a settlement either the day of the mediation or shortly thereafter. And that's a pretty high percentage. So you have closure, you have an agreement where everybody can agree to it. But back to your original question, mediation is basically alternative dispute resolution. Rather than going to trial, you can opt to try to settle your case, not through just negotiations between the lawyer, but you involve a person like me or an ombudsman or, a third party that comes in to help guide the settlement process. And that's what a mediation is. There are also advantages to mediations as opposed to going to trial. Number one is after a mediation, you will likely end up with a lump sum payment of the settlement. Whereas if you go to court, whatever the judge awards you, whether you're a permanent total disability case or a permanently partial case, if they have to pay you what they owe you in the past in a lump sum, the accrued benefits. But anything that's owed in the future, the judge cannot make them pay you that in a lump sum. So you're going to be getting your comp rate or the 220 cap or whatever. Whereas at mediation, you will get a lump sum and the money will be in your hands. The other thing we can do, and especially involves permanent and total disability cases where the client or the employee is either a Medicare recipient or is about to be a Medicare recipient, and we can fashion the settlement, which means they're receiving Social Security disability benefits or shortly will be. We can fashion the settlement and in the paperwork use some language in there that spreads their lump sum payment over their lifetime so that it does not offset their Social Security benefits. They get both the lump sum and the Social Security, whereas if you go to court, the judge cannot do that for you. If there's an offset, there's going to be an offset. So those are the two major advantages of mediation, and closure is also the other thing.
I was going to say, David, what do you see from your clients from a stress standpoint when you're able to represent them in a mediation, you get a deal done? And what are you seeing? What's the feedback from your clients, particularly those who tell you, we don't want to try our case in court. I don't want to go to court. I'm too nervous. I can't handle that.
Yeah. And that's why mediation is a great option to litigation, because certain clients just don't want to even file a lawsuit, and especially don't want to go through the litigation process. It's too stressful for them. So the quickest way to get them a settlement and to be done is usually mediation. And we have good success in getting cases resolved for clients. But as a lawyer representing injured workers, we have to do a really good job on the front side before mediation starts, at preparing them, at setting expectations, at explaining the process, giving them ranges, and just kind of laying out the process for what mediation is like to get them comfortable with it. So we do spend a lot of time with our clients prior to mediation.
And that's a good thing, because David, you'd be surprised how many lawyers don't do that. They don't prepare. I mean, workers' comp in Alabama, it does not compensate the injured worker for what they've been through, whether it's permanent total or permanent partial. It just doesn't do it. I mean, the numbers we're working with, are the numbers that were in place when Ronald Reagan was the president, right? So it's hard for the plaintiffs to understand, the claimants to understand that they have these catastrophic injuries and they're very limited in what the recovery could be. And I often hear that, they get so frustrated hearing the low numbers coming from the other side that they say, I'll just take my chances in court. And I'll say, do you really? Let's talk about what happens when you go to court. Because workers' comp judges in Alabama are very limited into what they can award. There's a mathematical formula. It is based on three basic factors: how much money you're making, how many weeks are owed, and then the X factor is your impairment or your disability. And I talk to my faces blue to them. That's all the judge can do, is just plug those numbers in, and that's what it is. And guess what? You're not going to get that number in a lump sum either. So we'll just let the judge decide attitude doesn't work a lot. So.
Steve, you're so right. And what David said as well. Most of our work has to be done prior to the day of mediation, because if we haven't properly mentally prepared the client then we've got a bigger battle. And
Yeah.
that's the expectations have to be tempered. But we're going to pause that. It's been a fantastic conversation, but this is truly the saddest time of our hour each month, Steve. It's when we have to part ways with our guest. As much as our mother would want us to go on for hours on this show, we have to be respectful of those who watch and support our efforts here. But we want to thank you, Bud, for hanging in with us today. I hope we weren't too harsh on you.
No, so totally enjoyed it. Always great to be with you guys doing this and hanging out together, having lunch together and mediating together too.
Dave, it pains me to give you the last parting words each month, but that's in our contract. So go for it, bud.
You know, one of these days I'm actually going to prepare some thoughts and say something that is profound and educational. But until that time comes, y'all have a good afternoon.
Yeah, one of these days, whatever that is going to be, we'll be able to put it up on the wall and we'll promote that you said that on this show. Well, fellas, again, thank you. We've run through 5 different articles and a bunch of just Alabama-based work comp nuts and bolts. It's stuff that we deal with every day, every week. We've done it for years, and it's stuff that's new to our clients, but it's also things that they need to be educated about. So thank you, fellas, for sharing your expertise and your experience. Guys, that's going to conclude this month's Work Comp Today, as we do each month. The 3rd or 4th Thursday of each month, we'll be back. Let's see, this is October. We got one in November. We're going to skip December as we usually do because it's just a crazy